Hello, everybody. You are here for what is so smart about intellectual property. And I'm going to pull this up. My name is Chris Simcox, and I'm here with Bruce Zimber, and we are both professors at Bucks County Community College. And we're here today just to give you kind of a baseline about why intellectual property is important to all businesses, not just entrepreneurs, businesses that have always been around, those that are in artistic businesses, every business, this asset is going to be so important. We're just going to give you a little snippet today of the different types of intellectual property. So I'm going to show you this picture, and Bruce and I are going to kind of help you guys out since we're in a record mode here. But take a look at the picture and see if you can identify some of the types of intellectual property that we might see in this picture. And since you guys aren't here with us, we're gonna kind of jump in.
Okay, Chris. So here we have a typical desk setup with some computer equipment, some electronic devices, a telephone, a headset. I think I even see is that a VCR tape?
Might be.
Okay.
That might be a little bit old, but yeah, that's there.
And some earbuds. What intellectual property do you note?
Well, I think we can talk about patents, obviously. A lot of the different types of equipment we have here are patent. They're ideas of how they were made are patented, and we can talk about that a little bit later. But things like the actual computer technology, the phone, the mouse, the earbuds, the headset, all of those things were designed by somebody and are probably patent so that somebody else can't come up with the same idea.
Sure. And each one of these items not only includes technology, which is patentable, which hopefully keeps it unique from other technology used by other companies, or at least the company that developed it would get paid for licensing that technology to some other company to use. But we also have things that would include trademarks, a trademark being a name or symbol or something else representing a particular company's name and products. So we see a phone here. I'm assuming it's an iPhone, and the name iPhone would be a trademark. The little Apple design that would be on the back of the phone would also be a trademark. The headsets that are here probably have logos on them as well. Both of those things, those would have identifying either symbols or names on them that would help a customer know who was the manufacturer of those products.
And I think that most people are familiar with copyrights with the idea of music. That's where most people think about it, right? So, but businesses have a lot of things that are copyrighted or can be copyrighted that don't have anything to do with music at all. If your website, there's some language here that's on the computers. I'm not sure what that is. I tried to look as closely as I could, but I couldn't tell. But if you have a website and you have, blog articles, or you put out your own material there to try to educate people or get them to know about a particular topic, that's copyrighted. It's your ideas and you're trying to copyright those. So some of the language that you use in your websites and the kinds of things you use to market your business, those things can be copyrighted so that somebody else doesn't take those ideas.
Okay.
All right, so since we identified some of those in the picture here, let's just talk about what intellectual property is. So basically there are three main types of intellectual property, and we're going to talk about these three here today: copyright, trademark, and patent. And these are about protecting your ideas, your designs, your ideas of a way to manufacture. All of these things can be protected so that your business can keep them for themselves and keep them from other people using them. So we're going to give you a little bit of information about each one, And I'm going to turn it over to Bruce, and he's going to talk a little bit about trademarks.
Okay. Trademarks, what they are is embedded in the title. They are the marks that identify your trade, your business, and it helps distinguish your entity from others. And these include anything, logos, slogans, taglines, packaging. However, they are usually only specific to your field or business industry. So, for example, Apple is identified with telecommunications and computers. It is also now known for television, other forms of entertainment, radio, music sales, etc. When you trademark something, you typically trademark it within a particular uh, specter of use. So that if someone else is selling, let's say, um, I don't know, some kind of food item, and they want to refer to it as apples, it's not an infringement on
Right.
Apple, the computer product. And if someone is selling some kind of, let's say, makeup, again, Apple would not necessarily be protected. But it is a formal effort that you make to declare to the world that this is the marks and words that I am using to identify my business. You do this through a formal application. There is research that's typically done on it to clear it. And as you can see here, you typically get a 10-year term with a 10-year renewal. Trademarks have to be identified clearly with either a TM or an SM for a service mark, or the R in the circle, clearly indicating that something has been registered formally. This declaration informs the public that you consider this uh, logo, typeface, font, whatever it is, to be trademarked and available only for your use. Simply using the symbol does not mean that the items are protected under trademark law. The only way to actually do this is to register your services through the proper channels. Trademarks work by keeping your competition from copying or infringing on your business. It also lets customers know that they can expect consistent quality from your business. So, an example, Nike is a very powerful trademark. It consists not only of the name, but also of the famous swoosh. And in fact, that swoosh is so powerful that many times you'll see a Nike ad where they don't even mention the name, they just use the logo. The same thing could be said for Apple. Their Apple logo is so powerful that it also can stand in place of the name and the logo together. A benefit of large scale nationwide or worldwide companies is that Customs and Border Patrol services can detain and destroy infringing items that come into your country once you have federal trademark protection. As we know, there's plenty of counterfeit products that are out there in the world that try to take advantage of the value of those actual trademarks. So you can buy a Louis Vuitton bag, cost being X thousands of dollars, I'm not exactly sure, or you can try to buy you can try to buy the same bag out of the trunk of someone's car. And it may in fact look alike, but it's highly likely that it's identical. It wouldn't necessarily be identical in the quality of the materials being used or the construction of the item, let's say stitches per inch, or the type of zipper that's used, or the compartments that might be placed in that bag. Customers want to be confident that they are getting what they are paying for. And so, therefore, having trademarks in place and having legal entities such as customs agents defending those trademarks can be very important to a business. You can also use your trademark application in the US as a baseline for filing trademarks in other countries. Protecting your trademark is a proactive process. How to apply for protection? Well, there is a very specific U.S. Patent and Trademark Office. There are specific forms you have to fill out, information that needs to be given, and then there is a processing time in which they look to see if there are any infringing trademarks or anything out there that others want to protest before they will grant you that right. It is important to understand that the trademark process does not include every word or logo that's out there. In fact, there is a lot of controversy at times about this. Companies will look to try to trademark names because then they can consider it to be their asset. An example, T-Mobile is trying to trademark the color magenta because they use magenta in all their advertising. It's their logo. It is how they show that they have coverage across the US. However, it's a bit sketchy to say that I own a color. You might be able to say I own a color in this particular industry to indicate coverage of cellular service in a particular area. But you'd be hard pressed, I think, to push through magenta in general.
And I think that I would just say that a lot of times you had already said this about the trademark. I mean, people think that they can just put a, an R in a circle and put it next to something, and that makes that thing theirs. And, people do, they do police this, and it's not going to be something that you want to get yourself involved in doing it the wrong way rather than the right way when you can actually protect your property. All right, so let's talk a little bit about patents. So I think when most people hear the word patent, they're thinking about inventions, product design, things that people come up with as far as a new product. My pillow, that's, I designed that. Or, as we talked about before, the Apple, but, we've got all different types of things that can also be patented, not just physical devices, but the processes themselves. Sometimes business systems, the way you set up something can also be patented. So the law is here based off of, what the actual official definition is. And it just says whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent. So you can even obtain a patent on an improvement of a product if that's your particular idea, came from your particular head. And they divide up the types of patents we have. We have utility plant, we have design patents. They last for different types of periods of time. For example, the utility plant lasts for 20 years from the date of filing. Your design patent lasts for about 14 years. And you have to make sure that your patent's in the right category so that you get the right length of time for your protection. And I think that I always use Shark Tank in my conversations. I don't know if you do, Bruce, but Shark Tank is just a great example of, how businesses will come and they'll try to launch their business. And they've already tried to get patents, and the patents are pending. They always say the patents are pending. What does that mean? Well, they've applied for the patent, but they haven't gotten it yet. And until they can actually patent that process, it might not be protected, and there could be infringements, and that might, decrease the value of that particular, product or business or design, right?
In the case of Shark Tank, they're always saying the value of the business is relevant to the proprietary property that the business may own. And if they don't, in fact, own that patent, then what are they buying? What are they making an investment in?
Right. So, I think that one of the big concepts we talk about in business plans is, who's going to invest and how are you going to be able to make money to actually grow your business? This is one of the ways. I mean, if you have protections on these processes, then you can sell your business a little bit better. So the utility patent is made for new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. It's usually based upon how a certain invention works. Design is how an invention looks versus how it works. So design is going to be new and original ornamental design, something that is designed a certain way. So when we patent things, we have to make sure that they're in the right category. And maybe you have something that has both a utility as well as a design. And both of those things you need to actually make sure that you apply for a patent and go through that process. That process is, the purpose of it is to exclude others from what? Doing the same thing, making the same thing that you have. I mean, how many times have you come up with an idea in your head and then you see it on TV? That always makes me really angry. I mean, I'm like, oh, I had that idea, right? Somebody already has it. So, it keeps them from making, it keeps them from using. They can't offer to sell what something you already have. And then it also gives you the right exclusively to sell your invention, and that's throughout the US, or to import the invention throughout into the US. So these are the things that you're getting a patent for, is to make sure that your rights to these things are exclusive and somebody else doesn't have the right to take those away from you. And again, remember, for periods of time, if you have it for a period of time, you've got to renew that patent, or else that expires. So patents are granted, and usually, somewhere, we just talked about the different timeframes depending on what category you're in, and you're going to file for that particular category, and you're going to have to be the sole controller of the invention. So that means you're going to make or sell a product, or you're going to license it out to others. If you're going to ask for them to license it or control it, you still have to be in ultimate control. So if you're giving it to somebody else to do something with, if you're getting the patent, your business has to be in control of that. And then at that point in time, the product is going to go to the public domain, and it's going to be something that'll be out there, but it'll be protected for you, based upon your idea. You apply for that patent protection, again, US Patent and Trademark Office, same thing that Bruce said for the trademarks. And you need to, usually you can see the length of time is much different than what we were talking about with trademarks. It's about 2 to 3 years for you to receive your patent in this case. So just as we went back to in the beginning, it's like you don't own that until that patent actually comes through. So you can't necessarily, advertise that you're the owner of a particular product or the design of a product until you actually have the patent to do so. So, if you have, a situation where you've come up with a design, your business has come up with a design, you want to make sure that you protect it and you try to file a patent to protect it. And typically we also have, somebody in the business who can explain and be very detailed about how that process came to be, so that your application is very strong. A lot of times we worry about weak applications. If your application is weak, the chances of you getting that patent are not going to happen. So you want to make sure that you have the people on board who are designing this, who have been part of that process as a team, to make sure that that application is filled out, and made sure that it's as clear as possible. The US Patent and Trademark Office come up with a 7-step strategy in filing your application for a patent. First and foremost, you have to brainstorm the terms that you're thinking about as far as what you're using and how you're going to describe what you are using. And then you're going to search it to make sure that there isn't other things out there already that have been done doing that. Then you want to classify, am I utility patent and my design patent? And then for each of those, there's an application process, and you need to download documents to do that. And that application process that is not easy to get through either. So you want to make sure that you have all of the right people to help you with that process, especially the people who are involved in the actual design or the actual product itself. These are the 7 steps that the patent office actually suggests to you before, as you're going through this application process. So you want to make sure that if you see any of these terms and they're being used over and over again, that you try to stay away from that. You may want to go back and search other terms before you actually go through your application.
And the last of the three that we're going to be talking about today, three types of intellectual property, excuse me, are going to be copyrights. And copyrights cover a very broad spectrum of content. In effect, it covers all creative, literary, and artistic work, such as written papers, research, photographs, and music. All artistic work, all academic work, all business technical content, all falls under this category. You can also copyright technical drawings and database contents. It is basically what you create and you put out into the world as your original thinking and content. It has currently a duration of the author's life plus 70 years, which means throughout your life as well into your survivors' lives, the rights to that product remain tied to the originator of it. Copyright actually gets created as the product is produced. It is in effect immediate. It belongs to you. In order to get protection on it, it not only needs to be original to the author, it does not have to be a totally new concept. However, it has to be tangible, as it has to be seen, viewed, perceived, or readable by machinery. Okay, so the copyright itself, I write a piece of music, I paint a painting, I write a report, I write a poem, I write a novel, whatever it might be, the originator of that work has rights to that work. And that work cannot just be used by other people or modified by other people without the originator's permission. There are some exceptions to that. Chris, correct me if I'm wrong. Parody is often considered an exception. There are some fair use exceptions where you might be able to use it as examples to illustrate something to somebody, but you usually have to retain it in its original form. In my classes, I often bring up the concept of sampling in music, where people will take a small chunk of another song and try to incorporate it into what is to be considered a new performance piece. At issue here is whether or not, one, that's original creative thought, is the idea of taking a piece from somewhere else and reusing it in a different way, truly original, and what happens if it's done without the original creator's permission. And you see this in popular music all the time, particularly in hip hop, where people will take samples from other songs and build entire pieces of music around a bass line or a refrain, and then that gets contested. The originator retains those rights in perpetuity, or at least for those lifetime plus 70 years until it goes into the public domain. When product goes into the public domain, it can be used without necessarily seeking permission and without having to make payment. It is why you often see in lots of movies and other works the use of classical music because no one retains the rights to that anymore, and it's available for almost everyone to use, and it makes things relatively easy. Can we move forward?
Yep, sorry.
No, it's okay. Copyrights, you can apply for copyright protection through the Library of Congress, through the US Copyright Office. from the application date to receiving your copyright is a relatively short period of time compared to the other processes, 6 to 9 months, but sometimes as little as 2 months. However, as I said earlier, the copyright originates upon creation. So you don't necessarily need to register your work in order to have this protection, but you have to be proactive in protecting it. And so if you see someone violating your rights, you have a responsibility to react to that. And so throughout at least popular in modern history and popular music, there have been some pretty significant, let's say, songs that have been challenged. Uh, My Sweet Lord by George Harrison was considered to be too similar to He's So Fine by the Chiffons. There was a song called Bittersweet Symphony by The Verve that picked up a sample from a symphonic version of Rolling Stone songs. Andrew Oldham, I believe, was his name. And it was years before the Rolling Stones actually gave permission to The Verve to collect the royalties on what was their biggest hit song ever. Um, for more information on copyright, you should definitely go to the US Library of Commerce site, to the Copyright Office Guide on Copyright Basics.
Yeah, and that class, the tape that they have on copyright basics is really good, as far as informational. And tend to turn a lot of people to that, just in case of they're not sure about something being copyrighted, or it should or it shouldn't be. And I think that the most exciting part about this topic is always the copyright infringement, because it always has these good juicy stories about what happens. The parodies are a big topic of conversation, is whether, what is a parody, and, how much do you change the song in order to be able to use it. I had a couple of parodies that I used to use in my class, that they would do law school topics to the song of somebody else. So they changed the lyrics, but it's the same music. And some of those were okay, and some of those were removed, from the actual YouTube and all those sites, because it parodies a very small line to walk. So I think those are always exciting topics to talk about. But today we were just trying to get into a little bit about the basics of this intellectual property. And as Bruce said, he just said it at the end here, there isn't any infringement police. This is your property, and you need to protect it. So once you've decided to make sure that you have a copyright, a trademark, a patent, you are the one who's going to be monitoring. So you need to make sure that you're looking for violations on the internet. You're also going to, once you get that and you see it, you need to send out these cease and desist letters, basically telling somebody, this is a demand. You need to stop using that. It's mine. I already have it. Copyright, trademark, patent. And then, if there's nothing going to happen, if they're not changing their behavior, you have to sue. You have to follow through, or else they are going to be using it. And what happens is they weaken it. If you start to see people, if, Pepsi's so strong, Coke is so strong, why are they so strong? Because they're not going to let anybody weaken that mark. They're not going to let anybody else start using it. If anybody else is using it, they're going to follow through with these steps, and they're going to make sure it stops. If you don't do that, people start using it, it becomes very bland, and it's not yours anymore. So when it identified with your quality, doesn't identify with your quality anymore. So definitely important to make sure that you're policing this, and make sure you follow up on it once you found that it's being used improperly.
And Chris, to your point, even the biggest companies are not immune from people challenging them. So for example, there was an energy drink a few years ago called Cocaine.
Yeah.
And it was in a red can with white lettering, just like Coca-Cola. And Coke had to go after them because they're in the beverage business, and they actually sell their own particular brands of energy drinks. as well as they don't want Coca-Cola to be directly linked to cocaine, even though back in the olden days, it did have trace amounts of cocaine in it. Another thing, and if you don't mind me just adding, Chris,
No, no.
there are a lot of brands, trademarks in particular, that have been weakened over time based on the public's use of them. So, for example, people refer to tissues often as just Kleenex, or please give me a Band-Aid. And if you see a Band-Aid commercial today, they say Band-Aid brand adhesive strips because the product category is an adhesive strip. Band-Aid belongs to the particular company involved. You've had cellophane tape, which was a generic, but people were using the term Scotch tape. Scotch tape is a particular brand that belongs to 3M. So anytime someone sees someone even innocently using this, you have to raise your hackles a little bit and let them know that you don't appreciate what they're doing.
Yeah, because it's a snowball effect. So if it, one person starts doing it, then it feels like it's could be anybody and everybody. So definitely once you decide you're gonna do these types of protections, you're gonna then be in charge of enforcing it. And you need to also be concerned about you infringing on others. So if you're planning on taking something or you're planning on using somebody's brand and trying to rebrand it into yours, you need to make sure that you're doing this the right way, because there are some steep penalties for infringing somebody else's intellectual property, and that's going to be a detriment to you. So if you go out and you try to take something from somebody else but change it a little, try to make it work, you're going to end up losing that brand altogether if you end up, that you're using somebody else's stuff. So we want to protect the infringement of our stuff, but we also want to make sure we're not stepping on the toes of somebody else, because that's going to be detrimental to your business as well. So, what's smart about intellectual property? We want to make sure that you identify the intellectual property that you have, that you're going to follow the proper procedure to protect that property. You need to be aware of when others are violating your property, and you need to be sure you're not violating others, right? Because intellectual property is really important to a business. So if we can be smart about it, that's going to be awesome. So, Bruce, you have anything else?
Nope. Have a great day.
Thanks for being with us. Take
Thanks
care.
for joining us.